Welcome to A Lawyer's Guide to the Galaxy, a podcast about geek culture by lawyers with your hosts, Ben Siders and Kirk Taman.
And welcome back to A Lawyer's Guide to the Galaxy, the podcast that asks interesting questions that don't have any answers with your host, Ben Siders. That's me. And the other guy is Kirk Damon.
That's Kirk, as in the captain of the Enterprise.
We are intellectual property lawyers and certified geeks practicing law in St. Louis, Missouri. You can find me, Ben, on Twitter at Benjamin Siders. You can find Kirk at KirkDMN. You can find the podcast at LGGPod. And we're on YouTube, youtube.com/@LGGPodcast.
Some of you guys may actually be listening on YouTube now. We've had that out there for a little bit. So
I will say it's an extra step to get the podcast converted to .mp4 and put on there. So that's going to probably lag a little bit until I find somebody I can cajole into doing it for me so I don't forget. So there'll be a little bit of a time delay before the stuff gets on YouTube.
Sounds good. So it's definitely, if anybody who is listening on YouTube, feel free to shout out and say, yep, you're listening on YouTube. You found us on YouTube stuff. We want to figure out if this YouTube thing's popular or not. So
yeah, definitely. Okay, so today's episode, we are going to talk about something that I just found out happened this morning. I don't know how I missed this, but the great Margaret Weis and Tracy Hickman Dragonlance Wizards of the Coast dispute of 2020.
Which,
Kurt,
of course...
Did you hear about this?
That must have been reported front page news. No, of course.
I think it got lost in the greater COVID that was going on at the time. Like I talk to Margaret every once in a great while. I talk, she's probably glorifying it.
Via Twitter.
Exchange tweets with her about once every 6 months, and she occasionally responds. So I've been following her for all this time. I had no idea this happened.
Yeah, I had no idea this had happened either until you, Tracy, told me about it, even though it's interesting, and this is something that I think is fun for the purposes of this podcast, which is why we're going to talk about it. You presented this to me earlier today even, and said, hey, here's sort of my thought. I went through this, and I'm like, yeah, I think we can make a great podcast out of this. Let's do this. It sounds like fun. So we're going to talk about, the great Dragonlance lawsuit.
Okay, so if you don't know who Weis and I don't know how to pronounce it. Is it Weis or Weiss?
I believe it's Weis.
Is it all right? It's a German name, I think, and the I is second, so I think it is Weis. So Margaret, I'm sorry if you're listening if I pronounce it wrong. So we'll say Weis and Hickman. Weis and Hickman were hired by TSR in the 1980s to develop a new Dungeons and Dragons property, we'll call it, called Dragonlance, which you've probably heard of, but if not, it was a bit of a radical departure from how Dungeons and Dragons settings were previously developed.
Yeah, a lot of Dungeons and Dragons up until that point in time. That would say the settings were, they were just game settings.
Well, the main one was Greyhawk, I think,
Greyhawk
was the default
was
setting.
One. There was there was another one too. That was the other
Forgotten Realms was in there. Yeah. Probably slightly more popular.
Baldur's Gate around at that point.
Baldur's Gate is part of Forgotten Realms, I believe.
Okay. I'm trying to remember. There's another one I thought with Forgotten Realms.
Forgotten Realms is probably the one most people know best.
Isn't there an undead one?
I think there is. And there's the Dark Sun, and there's a whole bunch of them.
And so basically they had sort of these general environments that you
Ravenloft.
Ravenloft, that's it, Ravenloft.
I just pictured Lord Soth from Dragonlance, and it's Ravenloft.
That's so bad that we actually just got that way. So they were basically the idea that there were these settings. And if anybody who hasn't played Dungeons & Dragons, you basically kind of pick one of these settings as to what you're going to play in. That affects what's in it, how the general thing I said, it's the undead one is kind of the way I saw it. What's going to happen, the general feeling of like what it's going to be.
Is it going to be gothic? Is it going to be high fantasy? Is it going to be something else?
Yeah, of course, you can also make your own up. You don't have to play inside one of these
things.
Which
all of us did.
Yeah, all of us did. I mean, quite frankly, more of us probably made them up than used any of these. But they had the idea of setting up this new one, which is Dragonlance, which is also weird because it's kind of not a name of a place, whereas a lot of these were names of places.
Right, like it's a thing.
That
doesn't even exist when the story opens.
Yeah, it's a Dragonlance, so whatever. But yeah, that's sort of what it was. The biggest thing I think is really interesting about this is we have the idea of them creating this as a game supplement, but as opposed to it just being sort of there being fluff text in the game supplement, talking about it, things like that, we have TSR saying there's going to be novelizations. We're going to create novelizations and an actual book story. Yeah. And I think it's important to point out that, there's obviously stories in all of these. There's material in source books.
We should explain that. So when there's the source books that talk about the world setting and the unique creatures and give you sort of the background information, but there's usually also a campaign, sometimes multiple campaigns, which is a term of art for a pre-written story to play the game. Sort of like if you play like an RPG or a video game, campaign mode, you're familiar with that. It's the plot that the people who invented the game have already written for you to follow. You can also do sandbox and do your own, but the campaign is sort of the story mode.
And the campaigns usually, I would say not terribly long, usually. They're usually kind of straightforward. Some of them are pretty hefty. But it's, you know, and if you played Dungeons & Dragons, if you haven't done the Dungeons & Dragons starter set, like there's the island that you encounter at the beginning of that. That's kind of a campaign, you know, it's the starter set. But the real idea is to give you something prepared to go so you can just buy the product and you can play the game associated with it.
Usually you start, you make a character, you roll some dice, you pick out a name, you pick out a class, you pick out some equipment, you pick out a race, you're going to be an elf or a dwarf or whatever. And then you're off and running, and it's pretty straightforward. Not so with Dragonlance. That was not the idea.
Yeah, that's certainly not the idea with Dragonlance. And I have to admit, I never played in Dragonlance's universe. I read the books, but I never played in Dragonlance's
I bought the
universe.
campaigns and read through them. I never actually got a group together to play them, though.
Yeah, I played very little Dungeons & Dragons. I played mostly other role-playing games, and that's part of it. I mean, I played a ton of Shadowrun. We want to talk about Shadowrun. I can tell you about Shadowrun day in and day out. But it's one of those where, you know, I played Dungeons & Dragons a few times. I think we played I think we played one in Ravenloft, and I think we may have played one in, I don't even remember where it was. It's what it was, but it was like one of the earlier sort of, you know, campaigns, the real basic ones. Some of them were more basic. Some of them had more themes, again, sort of stuff like that. And we never played through prepared campaigns. We were almost always doing, you know, something the Dungeon Master had come up with that we were going to play with. So that was a sort of a lot of the experience I had with it. But Dragonlance created a setting, and you had this as opposed to it just being the sort of campaign in the book, and you also sometimes have fiction in the book, but it's going to be short things. So
little blurbs, flavor text.
Yeah, blurbs, flavor text. I mean, again, playing, you know, like everybody knows in this, I play Warhammer 40,000. The fans will usually refer to it as fluff.
Yeah, fluff,
the companies hate that, but everybody refers to it as fluff.
That's what it is.
And it's fluff text. And the idea behind it is it gives you a little bit of a feeling of what the feel is like, what the universe is like, but it may be a complete story, but they're like a page. You know,
at most, like the D&D source books, there's little paragraphs and you know, artist renderings of kind of characters that kind of help you understand how to play the game.
And you have backgrounds of backgrounds of certain areas. You know, they may give you a fluff text to explain like why this inn is particularly important.
You definitely don't usually have an entire trilogy of novels to go with it.
You do not have like novels to go with it, and that's the first reason I think to really pick on Dragonlance is the fact that this kind of was a unique thing. And I think it was.
Yeah, I don't think this was done much at the time. And the other thing that was odd in a good way is you weren't really supposed to roll your own character. You could, but there was these pre-existing characters they'd already made for you and kind of built the campaign around their personal stories, which although now that seems intuitive, it was kind of unique at the time, and it kind of made a lot of sense that in that kind of environment, you would also want a series of books to help everybody get to know those characters.
Yeah, and I think the idea behind it was were you interested in playing a prepared character that somebody else had created and sort of created a personality for?
At the time, nobody wanted to do that.
Yeah,
so it was a big gamble by TSR. Like, will this even work? Nobody knew.
But they definitely released these as novelizations. And I think the other thing that's really intriguing about the Dragonlance series is the fact that these novelizations became literature, so to speak, of their own. A lot of people read these novels that had never played Dungeons & Dragons and never did.
I didn't even know when I first found these books that there was a corresponding D&D campaign. I found that out later.
Yeah. And I think that, and again, sort of to me as the example, same kind of idea. Like I learned about these books because of, you know, people recommending them as fantasy novels, not as something for D&D, and then kind of found out that D&D existed afterward. And even though I played D&D after reading the novels, I didn't necessarily set it in Dragonlance, you know, or anything like that. We didn't necessarily play that type of thing with it. I wouldn't also say it necessarily directed me, surprisingly enough, towards the Dungeons & Dragons universe. What it was interesting is that these novels, and I think uniquely amongst many pulp fiction novels set in other universes like these, there's two trilogies that everybody talks about. The first one being Dragonlance Chronicles, the same one being Dragonlance Legends. Mm-hmm. Most people would say that Chronicles was just generally good fantasy trilogy.
Yeah, which is remarkable given that it kind of had to follow the structure of a D&D campaign, which it's kind of like writing a movie version of a novel. Like the stuff that works in a written novel, like prose form, doesn't always translate visually. Likewise, writing a video game doesn't always translate to prose.
Yeah, and I think that's the thing we have. And again, to me, these were commonly recommended as just good fantasy novels.
I was told once you've read Lord of the Rings, this is what you read next, Dragonlance.
Yeah. Oh, and I got it. You know, I was very into fantasy. I had read Lord of the Rings. I'd read, Anne McCaffrey's Dragonflight. I'd read the original Dragonflight. I never got overly into the trilogy. I was very into Terry Brooks. very into Piers Anthony, sort of things like that. And this just kind of fell into that. And quite frankly, that's, when I got to know Margaret Weis and Tracy Hickman, as authors. And I can't say I've read a lot from either of them since then, but partially because it's just I moved away from sort of that type of reading in my life. The other thing, we mentioned this earlier with it, I think it's worth pointing out. These are novels that were in some sense, I think, targeted to what they call the young adult section of the library. Yeah. They were really kind of teen novels.
Yeah, maybe early teen, seventh grade to I guess through high school pretty much.
Yeah.
Although I've read them all as an adult also, and everything else they published I've also read. So
yeah, and I read them I think primarily when I was in early high school. I think that's probably when I read them. I definitely read them in high school, I would have to say, if not middle school. But they were targeted to that audience, but they were not necessarily written as what we would call young adult fiction, so to speak.
No, definitely not. I always felt that they were a little more mature, not a little more, a lot more mature than your typical teen lit. They tackled more adult themes, and this is a testament to both Weis and Hickman. They respect their audience, and they just assume you can handle it. As a teenager, you recognize that when you're reading something.
Yeah, and I think when you read it, Chronicles was the one everybody recommended. Chronicles was the better of the two series. It was the first.
See, I disagree. I actually like Legends better.
I definitely know people who think Legends is better. I respectfully disagree with that. I think I'll always think Chronicles is better.
You need to read it again and tell me if you still think.
Well, that's the thing about it. They're novels that if you were to ask me about what were some fantasy series and novels that affected you during, sort of your, growing years, your young adult years. These novels are in there, and it's Chronicles and Legends are both in there, and it's with things like Lord of the Rings, On a Pale Horse by Piers Anthony. If you guys haven't ever read that, it's a great book. Magic Kingdom for Sale by Terry Brooks.
Yeah.
These are novels that are in there, but those are not novels that are associated specifically with any kind of alternative property. Now, I also read an enormous amount of the Star Trek novels. Those I would not say are fundamental, even though I probably read 100 of them. They're not things that I look back and say they sort of affected the way I look at that kind of writing. These are, even though I could say right now, I don't remember hardly anything about the plots.
Let's talk about why we're talking about it now, because these things came out in the 80s.
Yeah, these are in the 80s.
Why is it relevant now? Well, brands sell. When you have a brand, you've got something that immediately establishes an audience. And this all comes from the lawsuit we're going to talk about. So we have not independently researched any of this. We're taking it from the complaint. In around 2017, Weis and Hickman had heard through the grapevine, apparently, that Wizards of the Coast, who owned the Dragonlance IP at that point.
They had bought TSR. We talked about that in prior episodes. Mostly, I say down the success of Magic the Gathering. They had grown much larger. TSR is having trouble. Role-playing weren't selling as much. Wizards of the Coast had acquired TSR and all of the
And then Hasbro acquired Wizards of the Coast at some point after that. So we're in that corporate family. They approached Wizards of the Coast to say, hey, do you want us to write one more final Dragonlance trilogy? We've got ideas. To which apparently Wizards of the Coast was like, yeah, sure, let's print some money.
Well, and I think we were also starting to see in 2017 a return to role playing. I think when you talk about sort of the takeovers in the late 90s, it seemed like role playing was kind of fading. As a hobby. That is not true anymore. I think role playing
and that may be the rise of the internet, in the late 90s, early 2000s, and kind of distract everybody for a while. But us old farts all never gave up on the role-playing game.
Exactly.
Tabletop gaming is bigger than ever. So long story short, we'll kind of rip through the timeline, then we'll go back through. In 2019, Weis and Hickman get a license to Dragonlance to use to write their books. They go sign up with Penguin Random House to publish, I want to say, under the Del Rey imprint, maybe. I think it was in the pleadings. I don't remember, though. They start, and we'll talk about this in a second, they start producing manuscripts. Manuscripts get reviewed by the publisher, and when you're licensing third-party IP, also by the licensor. That happened. They got feedback. They incorporated changes. All of this is basically par for the course for any publishing deal. Until one day, a meeting was called where Wizards of the Coast basically said, according to the complaint, we're not going to approve any more manuscripts.
Yep.
Okay, well, if they don't approve them, you can't publish them.
And so we have a complete screeching halt coming, in conjunction with what's going here, but it's not over yet.
No, a lawsuit was filed a couple months after that. The lawsuit was voluntarily dismissed a couple months after that.
Which is presumably because it's settled.
Presumably. And then a couple years later, books appear. Yep. Dragonlance books, authored by Weis and Hickman. Which I actually saw them at the store a couple of weeks ago, and I was surprised, again, because I hadn't heard about this yet. But I was like delighted. I'm like, what? They're publishing new Dragonlance books, or did they rename old ones? But like they're in hardcovers. I was super excited, so I got to get them now.
When I saw it, I think I literally thought they were republications of the same thing, and was sort of like, wait, are they just changing the names?
I thought maybe I missed something because it's got the same Dragons of X format that like the Chronicles had.
Yeah, that was the titles. Dragons of they were
Dragons
seasons.
of Autumn Twilight, Dragons of Winter Night, and Dragons of
Spring Dawning.
Spring Dawning, yes.
Yep.
Then there was a fourth standalone book, Dragons of Summer Flame, that came out when I was in college. So, anyways, these are the same. I have no idea what they're about. So, but I got to go find out. Okay, so let's talk about this.
So what we're going to talk about, and I think the key about this, we're going to talk through the lawsuit. What we're going to do in this podcast, we want to talk through some sort of basics of lawsuits and kind of the way they work.
There's some interesting things here that bring up litigation issues, which we should say neither one of us is really a court litigator. Like we have the bar exam / law school 101 version of this stuff, but we have a couple of concepts that come up a lot in the law and that are widely misunderstood. But before we can really get into those, we got to give you at least a 30,000-foot view of how publishing agreements
So we're going to do that. We're going to talk you through sort of a little bit of the things behind this. Basically, just so you guys all know as well, we're basing all of this upon the complaint that was filed in this case, which is the one legal document we have.
The only document filed in the case, really. I mean, there's a couple little things, but
the important thing about it is that complaint is a public document. You know, you can go and you can access this when you file these documents, unless they're filed under seal, which is a specific way to say, hey, look, there's stuff in this that can't be made public.
Confidential information, trade secrets, information about minors, stuff like that. Not an issue here.
Yep, not an issue here. We're going to have you're going to make this complaint public, which tells the world kind of at least the assertion of the plaintiffs. Now, they're going to say a lot of times what the defendant did, but keep in mind when we're looking at it, we're saying this is what the plaintiffs said the defendants did.
Yep.
Whether or not they actually did that, whether the defendants would admit or deny, we don't know because we didn't have I don't even think we had an answer in this case.
No, I think it's settled before it was even due.
So, normally you'd have a defendant answer, which would say, yes, we deny absolutely everything you said, we said. But, those are sort of the initial documents. Yep. The real key behind this is we have no knowledge of what really happened behind the scenes in this, or what really happened in the case. What we have is a complaint, and we're basing everything upon that and just kind of our speculation of this is how cases like this typically go.
Yep. So let's talk about this publishing deal, because we were talking about this before we sat down to record. It's kind of odd, this three-way arrangement amongst Wizards, the authors, and the publisher, and each one kind of sees the relationship a little bit differently.
Yep.
And we really only have the author's perspective because that's what's in the lawsuit, but we can kind of put ourselves in the shoes of the others. If you're Wizards of the Coast and somebody comes to you and says, hey, can I license this IP you're mostly not using to go publish books? I'll do all the work. You can have some of the money. Why would you not do that?
Yeah. Now, again, usually the reason you're not going to is because, hey, you want to do this with somebody else.
Or you can't. You promise it to somebody else, or it's been optioned or something.
Or you really just don't want to do this. This is something you don't want to be involved in, whatever it is. But at the same time, these are established authors that have written in this universe before that were very well received for writing the universe before. Why would you not necessarily want to, enter into this?
I mean, these two are the fantasy equivalent of like Steven Spielberg coming to you and saying, hey, can I make this movie?
Exactly.
Of course you're going to say yes.
I want to make this movie out of your IP. Yeah. I think that, you have that. So what Wizards of the Coast is probably looking at is, this is a relatively, straightforward, yes, you want to license the IP to do this, we'll license you the IP to do this.
It's a low effort for them. They got to review stuff, but they're mostly probably concerned about the Dragonlance trademark, the Wizards of the Coast trademark's going to go on the book, but they don't have to worry. They don't have to write it, right? Weiss and Hickman are going to write it.
Yeah, and they're going to want to have some review because they're going to want to make sure, hey, this doesn't say, you're not writing, softcore porn, something like that. We want to know exactly what it is. And there's a commonly provisions in a trademark, a trademark license like this, where basically they have the ability to say, hey, look, we want to make sure it comports with what the trademark is so that you don't harm our trademark by associating with something that's not supposed to be associated with. Now, that's a real minor thing in this case because it's not like you're making a product where you can change the product and it not be what it is. It's a novel. It's the Dragonlance universe is by definition open. So, as long as it involves dragons and swords and sorcery, it's probably
there's a lot of discretion there.
there.
But they do have basically effectively unilateral veto rights over anything that they don't like.
Yeah, there's usually something in it. But I mean, there's the unilateral veto rights are basically a protection to say you're not misusing the IP. Sort of a good way to put it.
So that's their point of view. So they've got to do some stuff, mostly review transcript or manuscripts. I keep saying transcripts. Review manuscripts, make sure that they're fine with it, provide feedback that the authors then incorporate into rewrites. A pretty typical deal. Virtually every publishing deal I've ever seen basically works this way.
Yep.
So that's their point of view. And we don't have a copy of the license agreement. It's not attached to the complaint, but presumably there's some amount of royalty from book sales that goes to them from this. So that's how they get paid.
Probably in advance, probably some form of royalties. They're going to get paid in a variety of different ways. Advances are common so that they can essentially have living expenses.
Well, they probably wouldn't get that. The authors would, not the IP company.
Sorry. Yeah. Well, they may on the thing.
It's possible.
But yeah.
So switching over to the publisher's point of view, if you're a Penguin and you have two legendary authors who come to you and say, hey, we want to write books that we know everybody loves. What do you think? Of course you say yes.
Yeah, that's in my mind. The publication was almost more obvious in this case. You have established authors that have already written successfully in this area saying we want to publish something else in this area.
Your biggest question is, but do you have the IP?
Yeah, do you have the license with Wizards of the Coast?
So when they show up and
necessary?
say, yes, here it is, or at least we're working on it, you're in good shape there. And that's an important distinction. The contract for the IP license is between the authors and Wizards of the Coast. Yeah. Not with the publisher.
Now, that wouldn't necessarily have to be the case.
No, it can be, but that doesn't seem like it's the case here. And I'd say that usually it's not.
Yeah, and again, part of the reason we know that is because of who's involved in the case and how they sort of portray their relative positions.
And then likewise, the contract with the publisher is between the publisher and the authors, not usually a third-party IP person. It can be, but it typically isn't. So,
and typically you're not going to do that because it's the publishers are paying the author for the manuscript to publish it for the publishing rights.
The publisher doesn't care. Like, as long as you've got the rights, the publisher's like, that's not my problem. I'm here to publish whatever you give me. The underlying IP issues, authors, you go solve that yourself.
Yeah, you kind of look at it as the publisher's mechanical, as we put it earlier. Their purpose is to put ink on paper and get it in bookstores. That's their goal.
So that leaves our authors. They're the only ones that are contracting with both parties. They got a contract with Wizards, contract with the publisher. And we should say the publisher usually also has editorial control over the manuscript. So our two authors have to wrangle two different sets of reviewers providing rewrites and notes on two different sets of criteria. One cares about the integrity of the IP. One cares about the integrity of the imprint. The authors just want to write an awesome book.
Yeah. I think the other thing is that you also have, the publisher also cares a lot of, is this going to sell?
Yes.
And is it going to sell to the audience I want to sell it to?
Yes.
So they also have the idea of saying, hey, what you're writing is too adult for a young, for young adult fiction. What you're writing is too juvenile for things like that.
Yep. Okay, so let's get into our lawsuit. What happens here? It all seems to be going fine. Weiss and Hickman write their manuscript. They submit it. They get some notes and some feedback. They incorporate those notes. And then one day we have a meeting where...
Do we know, by the way, if they've written the entire trilogy or was it only one book at the point?
I think at this point it was the manuscript for book one only.
Okay.
Although according to the pleadings, I want to say they had the entire 3-book arc kind of mapped out.
Okay.
I'm trying to find where this fact is, but at some point there's a meeting and they have a quote from one of the attorneys in the lawsuit. But basically,
we have an original manuscript that gets sent in and comes back with some changes.
Yeah, normal changes. Yeah.
Then it's approved. It actually is. So my understanding is that the original book one manuscript is originally approved by Wizards of the Coast.
I don't know if it's approved for publication so much as they say, here's what we want done.
Okay.
They incorporate the changes and they continue to work on rewrites.
Okay.
And then here it is. August 13th, the allegations state that a weird meeting was called with Weiss, Hickman, their agents, the publisher, Wizards, everybody's lawyers. And
as a lawyer, as soon as you have everybody involved and their lawyers, nothing ever goes well.
It's never a good
sign.
According to the complaint, it was a telephonic meeting, and the defense attorney for Wizards basically said that Wizards is essentially terminating the contract immediately.
Well, but the thing is, they don't terminate the contract.
So here's what the pleading says: when challenged about the grounds for such termination, the lawyer responded with, they're editorializing it a little bit, the nonsensical statement, "We are not moving towards breach, but we will not approve any further drafts." So that sounds like it's not terminated, because that normally a breach would terminate the agreement. So presumably, there's no termination for convenience clause, or they would have just invoked that.
Yep.
So
let's talk about that for a second. I want to talk about the termination for convenience clause and one of the things with it. So a lot of contracts, there's a recognition that, hey, we may want to end this contract for sort of any reason. That's commonly called a termination for convenience clause. What it basically means is, look, we have a contract, we have an agreement, but there may be a reason I want out of it. So again, Wizards looking at this and saying there's a termination for convenience clause here. Could be something like Wizards of the Coast saying, for any reason we don't want the books published, we can just say no. And that's a very common thing. And that says we terminate the contract, it ends the contract. Typically, there's a penalty for doing that.
Yeah.
You're going to have to pay some amounts. People are going to get to keep some kind of an amount.
They usually call it a kill fee. Like if you, in creative, if you terminate something while we're halfway through working on it, you have to pay some kind of kill fee. I've seen it be anywhere from 10 to 25, sometimes higher percent of what the contract value would be. I don't know how that would apply here with an IP license, though, because they're not the ones that are paying anything. They're supposed to be getting money, presumably, for licensing the IP.
My guess behind it would be those. And again, when you think about, why do you have something like this? It's because you have people that are, preparing to do this. They're obviously sort of gambling on this thing releasing in the future. They're putting a lot of effort into writing it. Now, they may be getting paid for that writing. They may be getting in advance to, cover it when we don't know. But the idea being is there was an expectation of a large future success, or at least
$10 million was the estimated market value of the series.
And so, something like that, well, you have that kind of stuff going forward. What if you're going to kill this, if you're going to say, we're not going to go forward and it's our sole decision to do so, it's not that, hey, you can't write it or it's not meeting our criteria, we don't like it, and these are the specific reasons why. This is for convenience. This is for any reason. There's usually that idea of saying, look, that's kind of on our head. We get to do it, but look, we'll compensate you for the time and effort you put into this.
I'm guessing there's no such clause, or they would have just invoked it rather than say what they said, according to the complaint.
And that's a really interesting statement in the complaint, because it also sort of says we're not breaching the agreement. So it's not that we're saying you can't write the drafts and publish them, but we won't approve you to write and publish anything, and our approval is required.
And we're going to approve nothing.
Yeah, so you can...
Well, that's weird, right? Like, where does that leave you? I can see why Weiss and Hickman were like, well, now what? Does that just mean the deal's just in limbo forever?
Yeah, it feels like in some sense the deal's not... the deal has been killed, but there's also a statement that the deal is not being killed.
Yeah, the contract's still there, but we're never going to move forward with it. Yeah. Okay, well, then there's not really a contract, is there?
So, and that creates the process. And when you look at this now and say, if you're in this kind of scenario, how do you deal with this? And the answer to it is, this is what courts are for.
Yeah, this is what the lawsuit was about. So the first claim that they file is breach of contract, which is interesting, though. Like, what's the breach? What requirement did they have that they've not fulfilled? It says they get to approve the manuscript. They're choosing not to approve it. Yeah. So what's the problem?
Yeah, they're not approving it, and they've said they won't approve anything. Where's the breach? Because they have the right to do this. And really, what we're going to get into is there's going to be sort of some implied, stuff related to breach of contract here and what it is. But the first thing we say you breached a contract, you need to have done something in violation of the contract. What's done in violation of the contract? Now, again, we don't have the contract specifically. It's not attached to the complaint. But a lot of times what it would be is there's going to be something in it that says you're going to only do this in good faith. Or you're going to do these kind of things, with the expectation of doing it. There can be throwaway clauses, so to speak, having to do with, are you being reasonable in your, yes, I can reject it for any reasonable reason. I can't just reject it for any reason.
Well, they did provide some basis for the breach of contract claim. They basically said that they originally said the contract's terminated. Well, terminating a non-terminal contract is a breach of the contract. It gives rise to damages. They got a couple other clauses. The lawyers did a nice job picking through this contract. And coming up with some things that are supposed to be done and weren't being done correctly. And
that's a lot of times what you also get into, where it's something where it's, hey, we're not really moving forward. There's oftentimes an obligation that you do things in certain timelines, and then failure to meet those timelines can be a breach.
Yeah. But the more interesting thing to talk about is the second cause of action, which is for something called breach of the implied duty of good faith and fair dealing, which every lawyer loves and nobody ever wins on.
Yeah, and then, so this is one of these like law school concepts we want to get into, and it's part of the idea of why we liked this case is something to go into, because this is one of those things you may very well hear about, you may very well bump into, which is, hey, you're supposed to be fair in a contract, and you can't just be unfair in a contract. And then there's sort of the other side of the, well, I'm following the contract. How am I fair and unfair? I'm following the contract. And, when you get into one of the things you'll hear periodically in conjunction with law school, when you're talking about contracts, you'll get an argument for what's called the four corners of the document.
Yes.
So it's basically the idea.
It's called the four corners doctrine.
Yeah. And so it's basically the idea that says if it's in the, the contract is what's defined within the four corners of the page upon which it is printed. And therefore, if you're inside the bounds of what that says, you're fine. And that's kind of what that says. On the other side of it, there's these equitable doctrines. And the equitable doctrines kind of say, yeah, we get that, but there's things that people didn't necessarily know about or didn't think about. And I think it's worth pointing out the time period of this is August. We said, we're in late 2020, so we're still in COVID, and definitely hard COVID. There's stuff that came out of this, of contracts having to do specifically with COVID and the fact that we'd never faced a global pandemic in the modern world before. So this is not a, completely unique thing being brought up in courts at this point in time, is these kind of, duty of good faith and candor. But that's what we're basically asserting in this, is that you're misbehaving under the contract.
And it's an often misunderstood doctrine. Non-lawyers sometimes get a hold of it and say, so-and-so is being mean to me, being a jerk, being unreasonable. Therefore, it's a breach of the implied duty of good faith and fair dealing. They're not being fair. That's not really how it works. The implied duty of good faith means that when a contract allows you to exercise your discretion, and it specifically says that, even though the contract may not say this, you still have to exercise your discretion in a way that's basically reasonable and fair. You definitely are not supposed to exercise your discretion in a way that defeats the entire purpose of having the contract and denies the other person the benefit of the bargain for no good reason.
There's a really good one in there, and that's the idea that it commonly gets the word reasonable thrown around. That's the thing you usually hear is being
lawyers'
reasonable.
favorite term.
Yeah, the lawyers love the term reasonable because it's one, hard to define, and two, very easy to
who can argue against that? Who can say we should do unreasonable things?
Yeah, we can't do unreasonable things. But the other thing that you go into it is it's one of the ways you can be unreasonable is to basically say, yes, I'm doing what I'm supposed to do under the contract for the purposes of not doing what I'm supposed to do under the contract. That doesn't feel right.
We have this in the government, right? We have due process. If the government is going to take some action against you, you got to have notice and the opportunity to complain about it.
Yeah.
Basically. If you don't have at least that much, you don't have due process. This is kind of an equivalent rule. You can't just arbitrarily do things under a contract for no reason other than you're trying to get out of obeying the contract. So that's what that duty means. It usually does not mean that you've actually breached an express provision, which is kind of implicit in the structure of the complaint. Count 1 is for breach of contract.
Yep.
Count 2 is for breach of the duty, not breach of the contract.
Yep.
If there's an actual term you could point to, that would just be in count 1. So this is saying even when they did follow the contract, they did it in kind of a rotten way.
Yeah, and again, the real thing you really, I think, encounter, and where you really encounter this is and quite frankly, popular culture and like you'll see it in TV shows and stuff like that. The idea of it being, that you'll hear the phrase following the letter of the law, if not the spirit. In some sense, that's kind of what this thing is it's saying, I'm following the letter of the law. I'm following the contract, but I'm interpreting the contract, or I'm following the contract in a way which defeats the whole point of having a contract in the first place.
Yeah.
And you kind of look at it and you're like, yes, that's right. It can't be a breach because you're doing what you're supposed to be doing. But if you're defeating the purpose of having a contract by abiding by the contract, that contradiction just can't be right.
Yeah.
The other side wouldn't have agreed to this. And that's really the way to look at it, is they wouldn't have agreed to a contract that says, my contract is that you're going to be legally obligated to not be legally obligated to anything. And it's like, no, it doesn't make any sense.
They basically said in the lawsuit, look, if you've got reasons, give them to us. Do you not like the story? Do you not like the characters?
Yeah.
Is there something that's inconsistent with your branding effort? Or are we pivoting the company in a different direction? We want to bring this along with it, whatever. Give me a reason that's got something to do with a legitimate business reason that pertains to this contract and this book.
Yeah.
But they got nothing.
And then, and quite frankly, the question is, their reason may be a breach, maybe a material breach. It may be
that was
something
the
they
argument.
really can't use.
So this gets into the broader social issue that we don't want to harp on too much, but this is also throughout this lawsuit, throughout the complaint, is that at the time, and I vaguely remember this, I think.
I remember it vaguely.
Wizards of the Coast was apparently embroiled in various, I'm going to broadly call it social scandals or controversies.
External PR scandals.
Yes,
external PR
that's a good way to
concerns
say it.
is a good way to put it.
Allegations of disparate promotional and hiring practices, maybe some sexism.
There were some cards people didn't like artwork
That's
on.
right. That's right. It was the Magic the Gathering cards.
Yeah.
Some of the older ones had some things that have not aged well, let's say.
Yeah, and I think they did some re-releases that were re-releasing older cards. And one of the things you obviously bump into is everything's a product of its time. Wizards of the Coast, Magic the Gathering has existed since, pretty much the early 90s. So it was created in a different time. Cards were created in a different time. And you may need a particular card and a particular concept that it has when you're bringing back into the game. As anybody who's played collectible card games knows, old concepts, old cards make a comeback. But some of that may not have aged well, and I think that was some of the stuff that they had with it there. Again, also, we're in the summer of 2020. We have a sort of radically world shift. We have COVID. We are in the midst of
Well, it's also
protests.
the summer of the George Floyd protests in Minneapolis.
So, the world is undergoing a sort of radical change, and one could just simply say, Magic the Gathering got swept up in it. Whether they by their own fault, whether by just sheer happenstance, it doesn't matter. But that is going on at this point in time. So I think it's worth pointing out that there's that kind of thing. And what I would say the complaint doesn't specifically say, but in some sense implies, is this is what led to the publishing.
It basically says that the rumor mill says. So they kind of go over some of these controversies in the complaint. Then they say this phrase, on information and belief, which means we don't know for sure, but we've got a good reason to think it might be true.
That's one of those great lawyer phrases, which literally means we're not sure, but...
They basically say that these various controversies were receiving attention at the highest levels of Hasbro, who presumably were not pleased.
Yeah, and presumably we're not pleased with Wizards of the Coast.
Right.
And I think it's one of the rumors that's also sort of in there is that this may have come from Hasbro, that, basically there was a Hasbro telling Wizards of the Coast, which it owns. I mean, they control their subsidiary, saying, kill this deal.
That's the part I do find a little confusing. The timing seems more than coincidental, so I understand why they're trying to tie the dots together, but Weiss and Hickman are not known as being like controversial conservative curmudgeons who don't know how to do diversity or inclusion well, like quite the opposite. So
Elves, dwarves.
Yeah, like that's the whole point of the fantasies. You have the nauseatingly diverse party of people who overcome their differences and work together, right?
I always think it's amusing is if you want to talk about diversity, it's hard to see more diverse than Dungeons and Dragons. Admittedly, it's because they're all not human, but that's
that should make it even harder to get along, right? I mean, if you've ever seen Lord of the Rings, you know Legolas and Gimli, right? So I guess maybe it was just a general paranoia, like what? No sudden moves, everybody. Like until we get this figured out.
Yeah.
But I don't understand why they felt the need to sit on this one in particular. Yeah. These two, I mean, maybe I don't just know the corporate dynamics, but these two authors to me would be like the least of my concerns.
Yeah, I definitely believe that. I think the other thing with it is we have a timing where we say, hey, that original meeting is alleged to have occurred August 13th, 2020. This lawsuit is filed October 16th, 2020. That's barely 2 months afterwards. That's very fast. So we also have to presume there's probably been other conversations, probably not something that can be raised in the complaint, any records about it. But presumably there was the assumption that this is not moving forward. This is not something that was a temporary hold.
What usually does not happen is you have this meeting and then nobody talks to anybody for 2 months and a lawsuit gets filed. Yeah. There's usually some ongoing discussions towards a resolution. Even if you have people who are really mad at each other, generally everybody will see enough of their financial interest involved to come to the table. But sure, filing a lawsuit tends to apply some pressure and shows that you're really serious.
A lot of times the filing of a lawsuit is to resolve the issue. The issue needs to be resolved. It needs to be resolved relatively quickly.
Well, think of
That's
it from
forcing the issue.
From the author's point of view, they've got obligations to Penguin too. They said we'd write the book and get you a manuscript. We can't do it now.
And let's point that out.
Which is the third count, which is tortious interference with the contract.
And let's point that out. That's actually a good thing. Remember we mentioned early the fact that the authors have 2 contracts here. One of which is with or 2 agreements here. I shouldn't say, One of which is with Wizards of the Coast. One of which is with Penguin. We have Wizards of the Coast saying this. This is all an allegation against Wizards of the Coast.
Yeah, they got sued. Penguin did not.
Penguin did not, and we're going to talk about that in a second. But it's also the fact that the authors owe something to Penguin. They have been threatened to breach their contract with Penguin if Wizards of the Coast is causing them problems. So not only do they necessarily have to deal with the fact that they may have this issue occurring with Wizards of the Coast, that issue may cause them to breach another contract, which itself may have penalty provisions, may have probably, we don't know what they think, again, about that contract. Interestingly, and that's what Ben just sort of mentioned, it's important to note, this lawsuit is between the authors and Wizards of the Coast.
Almost.
Well, almost. But key importantly, the publishing company is not involved in this lawsuit.
And neither is Hasbro.
But the publishing company is because right now, presumably, they haven't breached the contract with Penguin.
No, if anybody would be suing, it would be Penguin, suing them and saying, where's my manuscript?
Where's my manuscript? So we have that has not happened at this stage. That may be a backdrop of that concern, but it hasn't. But that may explain some of the speed at which this is moving forward because it's necessary to revive this. We don't know what the timing obligations, they may be up against time deadlines. We just don't know. But yeah, we have the idea that this lawsuit is filed. We also, again, don't have no idea what was discussed after that August meeting and before the October filing. But presumably, whatever it is, there was a need to get this resolved and get this resolved quickly. And the lawsuit was a way, in some sense, to force the hand.
Yeah. And it apparently was, because the lawsuit was dismissed in December, just about 2 months after it was filed, without Wizards having to file an answer or really even, I don't think even enter an appearance or anything in the case.
Yep.
So basically, for all practical purposes, the lawsuit got filed, mandatory civil procedure disclosures were made, and then nothing else happens until it gets withdrawn. Yep. And since the books have been published, presumably, everybody found a way to make this happen.
Well, one has to presume. So lawsuits are almost always dismissed because they're voluntarily dismissed because there's some form of settlement that occurs. We have no way of knowing what those settlements are. They're almost universally confidential.
Yes.
You never know what it is, but you can presume there was one. And in some sense, there kind of has to have been one, or else one side just simply decided they can't win. But at the same time, that's a settlement.
A settlement may be as simple as, we're sorry, we'll approve the manuscript, please withdraw your lawsuit.
Yeah.
And I mean, that may be all it took, who knows? Or it could be a bigger, more formal rewriting of the contract completely.
But again, this also occurred quickly. So we have to wonder if, kind of the concern behind this is there is this Penguin contract with the authors and a potential breach of that being part of the timing issue.
Those contracts, the authors have usually pretty firm deadlines when they have to get stuff done.
Yep.
The publisher needs to be able to plan, and they expect the authors to work around them.
And it would not be surprising for those to have pretty substantial damages clause if those are not met, too.
Yes. Well, yeah, I mean, if there's a breach, you might even claw back advances and all kinds of stuff.
Yeah.
So there's real risk there. Let's talk about one kind of weird facet to this. Not weird so much as maybe interesting and possibly more applicable to people who are of perhaps less fame and stature than Weiss and Hickman. When you look at the front, we were talking about parties. Who are the parties to this lawsuit? The plaintiffs in this case are Tracy Hickman, the dude.
Yep.
And a company called Margaret Weiss LLC, a Wisconsin limited liability company.
Yeah, which it definitely sounds like the author's name, but I'm pretty sure that an individual is not a corporation.
When I first read that, I thought of Dr. Zoidberg, a medical corporation from Futurama. But this is not unusual. This is what they call a loan-out company, where, usually musicians use it a lot, screenwriters use it a lot, but you organize what's basically a one-man operation, right? A one-woman operation in this case, organize it into a company that you can filter all the revenue and contracting through. And it's basically just you, but there are limited liability benefits and other things that go into that.
Yep.
It's interesting that Margaret did that, but Tracy has not. But we do see that frequently. We see that in movies and screenwriters. Some people have a corporation, some people don't.
A lot of this is sort of the how do you want to do business? How do you behave? There's potential tax implications. None of us are tax attorneys, but
definitely not. I don't even do my own taxes.
Yeah, there's tax implications around setting these kind of things up. A lot of times it's liability concerns and things like that. A lot of times it's also just ease of doing business. It may be easier, like if you have an agent, to have your company hire the agent as opposed to you hire the agent. Just because of where the money comes from.
It's definitely more complicated to contract when you have the LLC, and there's a lot more formalities to follow. Maybe we should talk about that real quick. So if let's say you're a fanfic writer, you're out there writing your Star Wars fanfic, you publish it online for free. Are you in business? Probably not.
No, probably not.
Probably not. It's what we call a hobby.
Yeah.
But you're not selling anything. Basically, are you trying to make a profit? No, then you're not really in business.
Yep.
That's the general rule. But if you were instead writing your Star Wars fanfic and, say, self-publishing through Amazon or something,
and you get a license from Disney as well.
Whether you have one or not.
Let's assume you get one.
If you get one, we're publishing whatever. The bottom line is you are trying to make a profit. You are in business. Do you have to form an LLC? And the answer is no. You don't have to. But you are in business, so you are some form of legal quote-unquote entity.
Yep.
What is that?
And that's why I kind of wanted to also put the idea of saying, hey, you got the license with Disney, you've done all these business-sounding things. You don't have to be a business to do them. And that was kind of my point behind that.
You can sign the license just as you, the individual person, like Tracy did here. Tracy is just the dude here.
Exactly. And that's it. But yeah, the question is, are you in business? The answer is yes. And the question is, are you a business? And the answer is yes. You're a sole proprietorship. And that's a particular legal term that basically says you're an individual doing business as yourself.
And the practical consequence of that is because you are a person doing business as the person that you are, whatever debts or liabilities you incur on behalf of your business, those are yours personally, person.
Yeah. Because you're a person. And again, part of the thing this jumps into is because it's oftentimes easier to say, this is a transaction between two businesses, even if it's not a transaction between two businesses.
But what it means is if your business goes into debt, if you get into hock to somebody, your car, your house, all the assets you own in your name, those are up for grabs.
Because that's the entity that signed the contract.
This is why Margaret probably has her LLC. It's a limited liability company, which means the company's assets are up for grab if everything goes to hell. But Margaret's personal assets are not.
Yeah, that's not 100% doctrine. You can break through LLCs.
You can if you don't.
Keep stuff separate.
You have to treat the LLC as a separate person. You have to have proper insurance, and you have to run it like an LLC, and you can't commingle funds, and you have to not just treat it as an extension of yourself for tax deduction purposes. That's what a sole proprietorship is. And a lot of new LLCs don't know how to do that yet. It does take a little bit of a sort of a muscle to build up. Margaret, I would assume at this point knows what she's doing.
And or has people who know what they're doing.
Or more likely she has managing it for. But it's an interesting difference that Tracy did not. It may be as simple as the nature of his writing profession just doesn't need it.
Yeah. And the other thing with it is, again, a lot of times the reason you do this and just, being involved in sort of, business type things myself and variety of LLCs, sometimes it's easier. So if you need insurance, for example, to do something, it's sometimes easier to get in corporate insurance for, liability risk as an LLC than it is as a sole proprietorship, because the insurance company knows how to, insure an LLC and what its risks are, but they don't necessarily know how to insure a sole proprietorship in the same way. So a lot of times it's one of these things where, and again, what we like to point out about and why we're kind of playing around with this is we have two authors, one of whom did this and set up an LLC, and therefore the LLC is the party, presumably because the LLC signed the contract with Wizards of the Coast and got the license. The other person is the author themselves, who presumably they themselves signed the agreement with Wizards of the Coast and got the license. Both methods work. Both methods are totally acceptable, and we see both of them being used in this case. But we also see there's different reasons to use each one. And so again, it's one of those kind of things we wanted to point out that, you know, as a lawyer, you just kind of read over and don't necessarily think about, but as somebody who doesn't encounter this every day.
The average person looks at it and goes, why is it different between these two? Like, is there some court legal reason? Like, no, it's just how they choose to organize their business.
And why is this person a company? Well, because the fact that a lot of times he uses the same name and stuff like that.
I wonder if this is where all the sovereign citizens get this weird idea, like, oh, if you capitalize it, you're actually a reference to the shadow corporation the government sets up when you're born. So, and that's a topic for another day. We could do a whole episode on sovereign citizens. So let's also talk about a non-party, Hasbro. Hasbro is discussed a little bit in here. It's kind of suggested that they may be at the root of why this was not. Why are they not a party?
At this point in time, Hasbro owns Wizards of the Coast. That's a sort of public fact. At this point in time, Hasbro owns Wizards of the Coast in some way, shape, or form, recognizing that there's a variety of legal creations about how they own them.
Presumably, it was an equity purchase, and they own all the stock because Wizards of the Coast still exists. With an asset purchase, it probably wouldn't.
Yeah, you don't necessarily know exactly what it is, but the whole thing. So why aren't they an entity? And well, the answer is because they probably weren't a party to the contract. Wizards of the Coast was.
What do you sue them for? I mean, you can't sue them for breach of contract. They didn't sign it. You can't sue for implied covenant of good faith because
they're not a contractee.
They don't have that implied duty. Tortious interference, maybe would lie, but maybe you don't have strong enough facts here to allege that.
The biggest question is you don't, even if you say this sort of statement in there, they imply these kind of things, you probably don't have the fact, but you do know you had this meeting with an attorney who presumably represented Wizards of the Coast, saying this is Wizards of the Coast position, so Wizards of the Coast arguably is interfering at this point in time.
Now, it's possible over the course of discovery, had this gone forward, that you would find emails, correspondence, and testimony that says, no, it wasn't Wizards, it was that man over there, pointing to the guy wearing the Hasbro t-shirt in the corner, at which point you could add a party in, but of course it didn't go that far. But that does happen from time to time.
There is times when obviously parties are found later on, you determine that something is. There's also the possibility that quite frankly, because it was filed against Wizards of the Coast, that may have been the wrong party, but that's simply who they thought it was. Again, since it didn't go forward, there was no correction.
All right, so one other thing I wanted to talk about that's kind of an oddity. We get this question from time to time from people who talk about, especially when going for trademarks, they want to get a trademark on the name of their business. It's a common misunderstanding, or my business name, I can't get my business name because somebody else already has it, therefore I can't use this trademark. The trademark and the business name are not necessarily, I'd even say often, not the same thing. The business name is just the sequence of English letters that appear in a database somewhere to say what the name of your company is so the government knows who to send mail to, you know?
Basically. And if you need to sue them, who needs to be the party to the litigation? Exactly as you just said.
And even if you're a sole proprietorship, you don't have to file anything with the government just to have the business, but you probably, I think every state requires you to have a registered agent to receive service or process. So I'm pretty sure every state you have to do that. I believe
in a lot of these things where you're a sole proprietorship, it defaults to you as an individual.
Maybe that's what it is, yeah.
In a lot of
if
these
you're
cases,
a registered entity, you definitely have to.
Yeah, if any of these registered entities, you have to. A lot of these where it's hey, we're going to treat you like a sole proprietorship. A lot of times the purpose behind it is we need you to be a sole proprietorship to make the law work from the state level. Mm-hmm. So you just are. But we're going to treat that sole proprietorship as exactly you for all intents and purposes. It's just we're going to make that statement because it's important to us to handle it on the far end of the state. So again, in certain cases, I think you may be in business as a sole proprietorship and you may not even realize you are. Now you can register those. There's ways to register sole proprietorships.
People do DBAs sometimes and things
DBAs.
Like that.
You may hear that phrase DBA.
Doing business as.
That's a good way to sort of indicate a sole proprietorship type of arrangement a lot of times where you're saying, this is me, but I'm doing business as some other name.
Yep.
But really, it's just me.
One other thing to mention is even if you don't have to file anything with the state, most counties, and if not counties, cities, do require some kind of business license or business registration for most types of businesses. Sometimes special certifications or approvals, like a restaurant has to have a food service license. If you're going to serve alcohol, you have to have an alcohol license. Those are handled at various levels, sometimes a state level, sometimes a county level, but those are all separate. And then another thing, I actually ran into this with somebody a couple months ago. Often if you are a creative type working out of your home, that's fine, but your rental agreement with your landlord or your HOA or your condo association may have terms about whether you are allowed to operate a business out of your home. And those terms are often broad and don't cover things like, can I write novels, using my computer, sitting at my desk, or I have to go down to Starbucks to do it, So those things, practically speaking, often don't come up. They're more concerned about people running puppy mills and stuff like that out of their houses, things that are highly disruptive. They're probably not going to find out about your fan fiction business. Yeah. But if you ever find yourself sideways with your HOA or something, that's the kind of thing that if they find out, they can make your life kind of miserable over.
Yeah, and the real thing, times just what you're really kind of bumping into with these things is it's basically, are you a business or are you an individual? And we kind of accept individuals do certain things, businesses do certain things. And if you're going to behave like a business, we want to treat you like a business behind these. A lot of times, quite frankly, the other reason it's also for is it's things like taxes. We need to know what tax form you need to file. If you're a corporation, you need to file it. The licensing stuff a lot of times bumps into, yes, if you're going to do business in this, you require some form of licensing. So again, it's if you're, somebody who says, hey, I'm my individual and I walk down and I, set up a lemonade stand on the, end of my driveway. Am I technically a business? Yes, you technically are a business. You're selling stuff. Is anybody going to really care you treat it like that? Probably not, because you're not doing anything as to what it is. But like if you want to sell, for example, like homemade jams at a farmer's market, you may be required to have certain forms of licensure to do that. Those may be very easy to obtain, but you may have to have them depending on how much you produce. For example, if you produce a small amount, they may not matter. If you produce a substantially more amount, it may matter. You may have to have stuff like that. This is where you kind of bump into this thing that eventually hits the point where they kind of look at it and say, this isn't just one person carrying out a small transaction. Is that person, you're behaving like a business.
I want to make one more point about the parties. It's often underappreciated how important getting the parties to a contract right is, especially by non-attorneys. And this is not what happened here, but I'm going to use it as an example. Suppose this license from Wizards of the Coast was granted to Hickman and Margaret Weiss, LLC. Okay, great. Okay. What if, through pure inadvertence, Margaret signs the publishing agreement in her name individually rather than through the company? Well, Margaret Weiss, the woman, doesn't have a license right from Wizards of the Coast. The company does. And so by using the IP, that is, strictly speaking, an infringement, right? Or at least a violation.
Because it's being used by somebody who doesn't have the license.
Now, is Wizards of the Coast going to go bust their chops over that? Probably not. Yeah. But we do see, this is where disputes come from down the road, where there is a fight and nobody was thinking about this and everybody's looking for some kind of leverage. This is the kind of technicality that gets blown up into a huge, expensive, complicated, dragged down knockout fight in litigation.
And it uses a simple example as well, assuming it was something that happened just by accident and it wasn't easily fixed by having a different party sign, which a lot of times if this is realized, the other party will just change the
like
parties,
an ovation or something,
some change. One possibility would simply be is that Margaret Weiss, the corporation, could license Margaret Weiss, the individual, if that's allowed underneath the agreement.
That depends on whether the corporation is allowed to sublicense, which I think here it is allowed to sublicense, but it might be limited only to the publisher.
Yep.
Which is going to have to, and the publisher is also going to have to be able to sublicense because they've got to get translations and stuff lined up in foreign countries too.
But so one of the things that I think that the key behind it is it's easy to look at in those kind of cases and say, hey, this is something that even in that scenario would be relatively easy to fix and probably would nobody really care. But where these things blow up is it's actually the LLC has two people that are part of it, not one, and one of them signs the other contract and the other one doesn't. Now the two of them are at odds with each other, and suddenly it's the wait, who signed what? And that's
you want to know why lawyers are the way that we are. This is why. And it's because getting these parties right can be very, very important in certain contracts. And again, in many contracts, it may not matter. But I would say most it never matters. Yeah. But if there's a dispute, it's going to matter.
It's going to matter, and they matter.
See here, who can sue? Yeah. Who's authorized to sue? It's the parties to the contract.
Yeah,
that's why Margaret doesn't name herself individually here.
Yeah, and similarly, Wizards of the Coast gets named presumably because the fact that they were the contracts, because they also own the IP to Dragonlance. The things you could also bump into is, did they actually own the IP to Dragonlance? Could you have the wrong party because of the fact that, hey, it was incorrectly transferred when they bought TSR? That's a possibility. Or did TSR own it when they sold it? These are all the kind of things lawyers deal with on a regular basis, is making sure this kind of stuff is all done in the right place. It's generally referred to as diligence. It's one of those things that you hear on a
we are T-crossers and I-dotters.
Yeah. And the idea behind it is just to make sure everything's right. Now, again, there's no reason to believe anything here is wrong.
No, this all looks it looks great.
It very well could be just because of the fact that there's no answer.
Yeah, nothing happened.
Would have had something, but to get pointed out. But the issue with it is that it looks like we're using this as an example of sort of talking about parties because it does show the interesting parties, which means somebody was paying attention. To what they probably need to be. Otherwise, they wouldn't have put these interesting parties like an individual, one being an individual author, one being an LLC, from the individual author.
Yeah, so that's really all I wanted to go over for this. I say all in air quotes. We've been going for 45 or 50 minutes now. We just thought this was an interesting little chapter that we hadn't heard about. It feels like these TSR properties never stop being litigated and fought over. But Kirk and I both are obviously fans of Dragonlance and of Margaret and Tracy.
I know, and I kind of want to go get these new trilogy now. I didn't even realize it was until this.
Well, and we should say, you and I are both writers of a kind. I've read probably more of Margaret's work than anybody else, at least in fantasy. I've read over 30 Dragonlance novels. These two by far write the best stuff. And in my own writing, I know I am deeply, deeply influenced by reading their works. So,
well, and I think in many respects, all fantasy is deeply influenced by Dungeons and Dragons. In some respects, and a lot of us, sort of get it to where it is.
Well, the tropes come from
there. And arguably, Dragonlance is the best well-known Dungeons and Dragons.
Yeah.
So if you want to say you're influenced by Dungeons and Dragons, you're probably influenced by Dragonlance.
It's one of those properties that you're probably influenced by it and have probably seen some of it without even realizing it.
The same way as you're probably influenced by The Hobbit.
Yeah, absolutely. Anyway, so we thought this was a fun lens to go through some unusual legal issues that we rarely get to talk about. We should say, like I said, we are not litigators. We're also not corporate lawyers. So
or tax attorneys.
We are being a little bit reductive here for purposes of producing a podcast.
And we're also basing the entire podcast on the information in one complaint.
Yeah. Which is presumably correct. We have Rule 11. You have to think it's right when you file it.
It was presumably correct when filed, yes.
So, at any rate, so that's it. So go out and buy those books. I know I'm going to. And if anybody does, we would welcome your thoughts on them.
Yeah, maybe we'll do a book review later on this podcast.
All right, that's all for this time. We'll see you next time. Lorem, play us out.
The views expressed by the participants of this program are their own and do not represent the views of, nor are they endorsed by Lewis Rice LLC, its officers, directors, employees, agents, representatives, shareholders, and subsidiaries. None of the content should be considered legal advice. As always, consult a lawyer. This podcast was produced and recorded in St. Louis, Missouri.